You're listening to the Cyberwire Network, powered by N2K.
It's not always clear that someone, when they're using a cloud-based tool that they may be used for the last 5 years, that there's a new generative AI feature that has been added to that tool that may go against, a policy that one of our clients has implemented, and being able to provide them with the wherewithal to understand when they're using those tools is important.
Hello, everyone, and welcome to Caveat, N2K Cyberwire's privacy, surveillance, law, and policy podcast. I'm Dave Bittner, and joining me is my co-host Ben Yellen from the University of Maryland Center for Health and Homeland Security. Hey there, Ben.
Hello, Dave.
On today's show, Ben has the story of California Governor Gavin Newsom vetoing a bill that would have regulated artificial intelligence. I look at a Virginia court shutting down the use of license plate readers. And later in the show, my conversation with Josh Rosenzweig, Senior Director of AI and Innovation at Morgan Lewis. We're discussing tackling security and compliance in the age of generative AI. While this show covers legal topics and Ben is a lawyer, the views expressed do not constitute legal advice. For official legal advice on any of the topics we cover, please contact your attorney. And now, a word from our sponsor, Cortex. Security teams face a barrage of more security tools create more complexity. More devices need protection. More specialized focus areas create more silos. The security landscape is changing fast. How can security operations transform to meet current threats? Cortex by Palo Alto Networks consolidates SecOps tools into an integrated platform and helps organizations stop threats at scale with AI, automation, and analytics. Learn more at paloaltonetworks.com/Cortex. All right, Ben, we got some interesting stuff to cover here today. Why don't you start things off for us?
So for the second week in a row, I'm going to be talking about a California, I guess this did not become a law, so I won't say a law, but a California bill dealing with artificial intelligence. Yes, that is my West Coast bias.
Okay.
If that makes you angry, you can leave a bad review for us.
California's got, it's practically a nation all of its own, right?
It really is. It really is.
Has enough people.
And there's a reason California has been forced to act here is that there's just been a vacuum of federal leadership on the issue of artificial intelligence, and states are really in the dark. I mean, they just don't know what to do.
Right.
This is a completely novel issue. AI presents significant opportunities really in every sphere of our life, but it also has significant drawbacks. And states are trying to develop policies where we can maximize the good and minimize the bad. So California, under the leadership of State Senator Scott Wiener, passed a bill through the General Assembly that would have instituted significant regulations against artificial intelligence. One of the controversial aspects of the bill is that it would have regulated the producers of artificial intelligence, so the platforms, and wouldn't have punished people who use those platforms or use those tools in a way that's significantly harmful. But this bill, which was Senate Bill 1047, would have required companies to test the most powerful AI systems. So once you reach a certain threshold, and the bill defines what counts as powerful, before they're released, and these companies would be held liable if their technology was used to harm people. So if there's a terrorist attack, there would be a cause of action available to people in California, even a cyber attack or a swatting incident, anything like that.
Yeah.
The company would be liable under this California statute.
Yes.
It could be sued.
Yes. This is Ben, this is my idea. We talked about this before. This is regulating AI like the FDA regulates pharmaceuticals, right?
It totally is.
Right?
But I just think it's unclear whether we should have a regulatory regime based on pharmaceuticals.
Yeah.
I just don't know the answer to that question. I think California Governor Gavin Newsom, who had this bill on his desk for a month, was struggling to answer that question himself. We had a lot of stakeholders on both sides of this issue. So against this legislation were, of course, most big tech executives, most major California politicians, including former Speaker of the House Nancy Pelosi, who has a lot of friends in the tech industry. And basically, their argument was that this bill would quash innovation. Companies would be hesitant to build new AI systems, realizing that they'd have to go through this rigorous testing process and that they could be held liable based on anything that happened. And, once you release these AI tools into the wild, you can't even imagine the potential harms that they could result from the use of these AI tools.
True.
And then you had some proponents of this bill, including kind of the major intellectual actors in the AI field. So researchers Jeffrey Hinton and Yoshua Bengio, they were arguing that the law would formalize commitments that the private companies have already made voluntarily. And you had the sponsor of the bill, Scott Wiener, say that the state just had to fill in the vacuum left by lawmakers in Washington, which means that currently AI is just not regulated at all. We have kind of some isolated regulations on specific subjects like use of AI tools for electioneering or laws against revenge porn, that type of thing, and other deepfake audio or video, but we don't have the sort of broad regulation. And the bill had already been weakened significantly as it made its way through the legislative process. Part of it was that they were trying to at least get big tech and Silicon Valley divided 50-50 on the bill. Right. Elon Musk actually came out in support of it once it had been whittled down, which is certainly interesting.
Huh.
But in vetoing the bill, Newsom said it's wrong to single out AI projects that use more than a certain amount of computing power while ignoring the AI system's use case. So the way the bill is structured is that it only applies to AI projects of a certain size measured by the amount of computing power that they use, where I think what Newsom would have preferred, and I think this is certainly a valid argument, is whether that system is used for things like critical decision-making or makes use of sensitive data. And he said that that would have been a better approach in terms of regulating artificial intelligence.
Right.
He's not against California taking a leadership role, but he thinks that we should just approach it from another direction. So Gavin Newsom is a cynical, conniving politician, like him or hate him.
Tell us how you really feel, Ben.
I mean, I've known this guy, having grown up in San Francisco, since he was young in his 30s and married to Kimberly Guilfoyle, who is currently in a relationship with Donald Trump Jr. And he's just like, he screams politician. I think he's very smart.
Yeah, he's certainly a handsome man.
He's very handsome with that slicked back hair.
Right.
My point is, I don't know exactly why he vetoed this bill. It could be that he did have good faith concerns that this wasn't the best approach to regulating artificial intelligence. It also could be that he just didn't want to upset big tech at this point in time. So it's certainly a monumental decision that he's made. I think the next step is legislators going back to the drawing board, working with advocates who work in AI safety and working with legislators to come up with an approach that's acceptable to him. And California has a full-time legislature, so it's possible that we'll see revised legislation sooner rather than later.
And no chance of the California legislature overriding this veto?
No, there's no chance of that. It did pass largely along party lines, but there was some Democratic opposition. It's a Democratic-dominated legislature, but I do not believe that there are enough votes to override the governor's veto here.
It's interesting to me that it made its way far enough along the process with all of the... Like, I saw a quote from Josh Wiener. Is it Josh Wiener? Scott Wiener, I'm sorry, from Scott Wiener, expressing his disappointment because he felt as though they had done good faith negotiating and, as you said, weakening of the bill with the parties involved in it, and he thought it was enough to get it over the finish line. But then we got this veto.
Yeah, I can understand why it's frustrating to him. I mean, I think he was trying to work constructively with these companies to come up with a solution that would satisfy AI safety advocates and some of these entrepreneurs who want to build these tools and not be constrained by burdensome regulations. And so I can certainly see that it's frustrating after you make all of these concessions that the bill ends up getting vetoed in the end. Which to me, it's like, have the conversations with Gavin Newsom himself, see what he's willing to accept, and then tailor the legislation to what he would want. Now, I think Newsom was kind of coy on all of this, and he sort of wasn't sure whether he was going to sign or veto it. So the legislature might have just been taking a shot in the dark. But yes, I can certainly see why it's frustrating. And Weiner, to his credit, talked about the real issue here, which is that we're creating these very powerful technological tools. And right now, there are no binding restrictions from U.S. policymakers. That's due to Congress's paralysis, and that's due to the fact that California, which is always the leader in formulating regulations in the tech space, has suffered this setback because of this veto.
Do general product liability laws apply to this sort of technology? I mean, if something is obviously defective, could someone sue them, or are they somehow exempt from that?
They're not exempt from it. It's just going to be a problem of having a successful lawsuit, going through discovery. There's basically no case law on this yet. And proving causation, proving that the negligence of the company or whatever liability one wants to attach to the company directly led to a harm without an explicit cause of action laid out in a statute like the one that went to Governor Newsom's desk. You just have this kind of legal black hole where we don't know how these cases are going to be adjudicated. So, yeah, it's possible that we see these lawsuits. But if you can't directly trace whatever the alleged harm is to the use of the artificial intelligence tool, and if you have no case law that guides judges in how to make decisions on these questions, you're going to be left in a world with a lot of uncertainty.
Yeah. I'm trying to puzzle my way through it, and for better or for worse, you know how much I love my analogies, and
you sure do. They can be far-fetched sometimes, but I do love them as well.
It helps me frame things, to try to understand them. And so I'm just sort of thinking about how companies are or can or cannot be liable for the things that their company puts out in the world. And on the one hand, you have these AI systems, which are kind of fuzzy boxes. And if you go back and say, well, why did this system generate this response or this command or this information? It's not the way that we're accustomed to most computers of working, where you can reverse engineer it and 1 + 1 = 2.
Right. It's not linear coding. It's the system spinning off itself. I mean, that's what artificial intelligence is, and going in its own direction.
And it's likelihoods of things happening, But on the other hand, I mean, let's say I have a business full of consultants who are flesh and blood human beings, and I have, 1,000 consultants who are out there giving people advice on what to do, and one of them just starts giving bonkers answers, right? They're still representing my company. It's my company's liability for not catching the bad consultant who just suddenly started giving bonkers answers. I'm still liable for that.
I guess, and I'm just kind of brainstorming here because I really don't know how this is going to go, and I'm shooting in the dark. But my guess is the way courts might see it is in all other instances when we talk about products liability, there is that direct linear relationship where you have a general idea of what the product is, how it works, what the process is in using that product. Like if you're producing a Coca-Cola bottle, what goes into the production of it, what the output is, how a person is supposed to use it, and what are the worst harms that can happen from a Coca-Cola bottle. The worst thing that can happen is you put a Mentos in there and it explodes.
Right. But if I suddenly start using Coca-Cola bottles for my juggling act and I get bonked on the head, Coca-Cola could make a good argument that is outside of the accepted use case of a Coca-Cola bottle.
Yeah, and then just multiply that by 1,000 with the use of artificial intelligence, because we have no idea. We can't even imagine what these tools are capable of.
Yeah.
We're just so far in the infancy of this form of technology that I think it's constrained by the limits of our own imagination. So that's why it's an imperfect metaphor. And I don't know how that's going to translate into case law. The best way to develop case law on this would be to give judges and juries guidance. And that's what the missed opportunity is here. You would have created some type of legal clarity, both for the companies that produce artificial intelligence tools and for the users. And you would have created a recourse for the citizens of California if they feel that they've been harmed in some way by these systems to recover damages. But at least according to Governor Newsom, this is not the right time and not the right approach, and they're going back to the drawing board.
Is it fair to say for the big tech companies that it's in their best interest for this can to be kicked down the road?
Yes, it's definitely fair to say that. They would probably prefer federal regulation for uniformity purposes and because whatever Congress came up with isn't going to be as burdensome as what the California state legislature comes up with. So yeah, if they can prolong this as long as possible. You never know, though. I mean, there's a reason that companies have worked together voluntarily to put guardrails on AI tools. I think if they realize that it's in everybody's interest to not let this become kind of an unfettered, unmanageable problem that creates such significant harms that it discredits the use of all artificial intelligence tools. I think these companies are keenly aware of that. So I think they're willing to be constructive partners in forming regulation. Most of them ended up not supporting this bill, but I don't think we should write them out of negotiations entirely because I don't think ultimately they want a world where there is no legal clarity whatsoever on the scope of liability for these tools.
Yeah, and I suppose it's inevitable that they'll have some guardrails put on them, so they want to be part of that conversation.
Yeah, and it's probably better to do that now before there's some catalyzing AI 9/11 incident where there's a public groundswell of people who want stricter regulation, and Newsom feels the political pressure and thinks that he's forced to sign any legislation that comes to his desk.
Right. No, that's good. Yeah, that all makes sense. All right. Well, we will have a link to that story in the show notes. My story this week comes from the folks over at Security Boulevard. They're looking at a case that was in front of the Virginia Supreme Court here, looking at a previous case that had to do with license plate reader technology, something that you and I have spoken about many times here, automated license plate readers.
We love our ALPRs, don't we?
Well, we love to talk about them. So in this particular case, there was a robbery at a video game store in Chesapeake, Virginia. And a witness observed a minivan leaving the scene of the alleged crime. Police put the license plate from that van into their license plate reader system. And then later on, they were able to find that vehicle, pull it over, and arrest the driver of the car for the alleged robbery of that video game store. This was all made possible because that community's police force had put in place a system of automated license plate readers. So these are motion-activated camera systems that take a picture of your vehicle as it goes by, examines the license plate, does optical character recognition on it, puts it in a database, stores that information for 30 days. And they had, I want to say, close to 150 cameras placed around their community to do this act. This judge in Norfolk basically threw this out. I guess a previous court had ruled that this was legal, that this was okay, but it went to the Supreme Court and they found that this was not okay, that this was unlawful surveillance without a warrant. Basically, the collection of all this information without any probable cause, just of people going about their own business, was not all right, and the judge shut it down. Interesting here also, they compared it to the case in Baltimore that you and I talked about where they had the airplane flying around.
The spy plane,
The spy plane taking pictures of everything. Talked about that as well. So those are the details. What do you make of this, Ben?
I'm really conflicted on how to view ALPR technology under current Fourth Amendment jurisprudence. So technically, when you're out on a public thoroughfare, you do not have a reasonable expectation of privacy under CATS. But that's also true for cell site location information. Prior to the Carpenter decision, I think the thinking was we don't have a reasonable expectation of privacy in the location information that we are sharing with our cell phone companies when we turn it on, because we are forfeiting that to some type of third party. We know that the cell phone companies are collecting that information, and therefore that forfeits our expectation of privacy. License plate readers are a little bit different. We are not handing those over to a third party, but we're also, I think if you looked at the letter of the law, you forfeit your reasonable expectation of privacy if you're out in public, which if you are passing an automatic license plate reader, by necessity, you're on a public thoroughfare. Where this becomes problematic is in the aggregate. If you have 172 license plate reader stations or whatever across a jurisdiction to the point where a person is under constant surveillance, then you start to creep into the world of Carpenter, where it's the volume, it's the breadth, it's the depth of the data collection, where you can track the whole of a person's movements that turns it into a search for Fourth Amendment purposes. And I think that's exactly the judge's reasoning here is if there was one location in a jurisdiction, maybe one toll booth that collected license plate information, that would have been okay. But when you're in a universe where these are so ubiquitous that they're everywhere and that you can track the whole of a person's movements over a significant amount of time through the use of this technology, then this becomes a Fourth Amendment search. My issue with it always, and this was my issue with Carpenter, is it's extremely hard to do any line drawing here. Carpenter didn't give us proper guidance, and I think lower courts are now just kind of guessing. All they said in Carpenter was that in that case, which was about 7 days worth of cell site location information collection, that was a search. But it didn't say anything about what that line is. Is it 6 days? Is it 8 days? What happens if it's a month? There's no line drawing there. Like I said, that leaves courts in kind of an awkward position of trying to guess how the Supreme Court would draw those lines in cases under different circumstances. So it's hard to know from a purely doctrinal or legal perspective what turns something that's not a search into a search. How many license plate readers does it take? We just don't have any clear guidance on it, and I think that's unfortunate.
Yeah. I'll share the last line in this article about the case, which was, again, over on the Security Boulevard website. This is written by Mark Rosh. And a little bit of editorializing here. Mark writes, "At the end of the day, the court skipped the whole public space and private space debate and simply decided that the practice of surveilling an entire community was, well, creepy. I'm sure that's in the Constitution somewhere."
I mean, you could say it in the sense of you know it when you see it, which is what the quote that's often cited in these types of circumstances.
Right.
I would like to not have jurisprudence based on you know it when you see it. I wish collectively we could come up with a test that would settle everybody's expectations. I think the best way to do it is a technology-based approach where you try and maintain the same level of protection that existed for people prior to that technology having been introduced. So if you needed a warrant to track a person's movement at 172 locations in a given jurisdiction, just because you now have automatic license plate readers that can accomplish that goal quickly, you have to restore the same level of protection that a person previously had, meaning there should be a warrant required to obtain that data. So that's my take on it, but courts have not agreed to that. They haven't really agreed to any approach. They're kind of just, in every case, is this close enough to Carpenter? Is this distinct enough from Carpenter? And it's just kind of up to the individual judges to make those decisions. It's not the best way of resolving these issues, but it's kind of the way these issues are getting solved right now. I'll also note that we just haven't had a Fourth Amendment case in front of the Supreme Court in the last 5 or 6 years. So it'd be nice if the Supreme Court could, among the 80 cases it takes every year, just fit in one Fourth Amendment case so that we could get further guidance on this. Mm-hmm. That's all I ask. I would consider it a personal favor.
I think you should send them a strongly worded letter.
Yeah. I'm sure they'd listen to me.
Oh.
I am
Justice Roberts.
So angry, good sir.
I'm just picturing Justice Roberts there, waving your letter around to the other justices.
I'm just thinking, who knows? I mean, maybe they're loyal caveat listeners.
Could be. You never know.
And this is my way of addressing them directly.
That's right. No, if you are a Supreme Court justice and you are a listener of this show, we would love to hear from you. So it's caveat@n2k.com.
Hello, my name is Clarence T. Oh, wait, that's too obvious. C. Thomas.
Um, Before we move on from this, I think a couple of little bits of nuance that are worth touching on. One, it seemed as though um, the judge was concerned with the ease with which law enforcement could access this collected data. It was in a database that any law enforcement officer could just go and use, as you say, without a warrant. But then also these license plate readers were placed in areas of the community where law enforcement believed there were likely to be crimes.
Yeah, I wonder what the characteristics of those areas are.
Right. So they were placed, much more likely to be placed in a, I'm using air quotes here, bad part of town than other places. And I suppose on the one hand, you could say, well, that just makes sense.
It's practical, yeah.
On the other hand, you could say, well, then who's more likely to get caught up in your dragnet? It's going to be folks who are lower economic privileges and people of color and all of those things.
I mean, we tried this. We tried this with stop and frisk searches. The legal standard for that is if you're in a, air quotes, bad neighborhood, then without a warrant, if you have reasonable suspicion that somebody is armed and dangerous, you can just stop them and frisk them. Only in bad neighborhoods, though. And I guess it is a live political argument whether that was an effective tool that the Supreme Court gave law enforcement agencies around the country, but it was certainly controversial. And I think these issues are going to be controversial if you limit them to certain neighborhoods, certain areas, certain demographics.
So last question here on this. Let's agree that you need a warrant to look at this information. All right, let's just say that's in our world, that's what it is. So do we need a warrant to collect the information into the database, or do we need a warrant to look at the collected data that's in the database?
I think from a practical perspective, it would be a warrant for querying the database.
Yeah, seems like it.
Because I think the collection is, you have to have the entire haystack in order to search for the needle in the haystack.
Right.
And the data at rest in these databases doesn't do much harm if it can't be searched without a warrant.
Yeah.
There are certainly instances you can imagine where the mere collection is offensive to the Fourth Amendment for one reason or another. But I think generally it's the querying that would concern us more.
Yeah, I would also point out that beyond law enforcement, there are private companies who do this as well, they cruise mall parking lots and park and rides, and they set up cameras coming in and out of neighborhoods to collect this information, to be able to aggregate it, de-anonymize it, and then sell it.
Sell it and make a ton of money.
Yep.
It's very profitable.
All right. Well, we will have a link to that story in our show notes. And once again, we would love to hear from you. If there's something you'd like us to consider for the show, you can email us. It's caveat@n2k.com. The IT world used to be simpler. You only had to secure and manage environments that you controlled. Then came new technologies and new ways to work. Now, employees, apps, and networks are everywhere. This means poor visibility, security gaps, and added risk. That's why Cloudflare created the first-ever connectivity cloud. Visit cloudflare.com to protect your business everywhere you do business. Ben, I recently had the pleasure of speaking with Josh Rosenzweig. He is Senior Director of AI and Innovation at Morgan Lewis, the well-known law firm. And we're discussing security and compliance in the age of generative AI. It's a really interesting conversation.
So I'll start by saying I'm not an attorney, never been a practicing attorney, but my function within Morgan Lewis is to help our practice areas, our attorneys, best use this technology and find ways to harmonize it with their practices. So I kind of sit between the legal practitioners and the business side of the firm in understanding, how and when we can implement these technologies in the best way possible, and recognizing that, as a global firm, we have a large portfolio of clients. We have a number of attorneys that operate in different industries and different disciplines, and trying to find ways, again, to like harmonize those things together. So for us, and for kind of my role, it's been, a balance of trying to, take advantage of the enthusiasm I think everyone has seen within this space. And there's been, obviously a ton of, early stage, research positions and papers around like how this is going to transform various professions. And legal has always kind of been at the top of one of those, those lists from some of the big four consulting firms around like the transformation of work and how generative AI is going to do that. But, as we started to look into the details of how this technology is implemented and adopted, one of the things that we found was that, yes, it's easy to provide access to, a ChatGPT or other type of, AI assisted tool. But for legal professionals in general, they have their kind of own professional responsibilities that they have to maintain around confidentiality, with clients and client information. And then we also have, again, a large portfolio of clients, both large and small, that have varying positions on the use of AI with their data. So we're having to navigate, this wide spectrum of clients that are very enthusiastic and want to start using, AI and generative AI in the delivery of legal services. But we have other clients in more regulated spaces that are nervous about, the unknowns that I think that everyone is experiencing around security and confidentiality with this information and how it's being used within large language models.
So is it fair to say that, the curiosity about this technology is coming from both sides, from both the folks that you do business with, but also people inside your organization?
100%, because again, we have clients that are in the tech space, so they're obviously developing solutions around these tools and for commercial purposes, and they have their own legal departments that are trying to take advantage of these solutions in making legal work more efficient. And we have obviously attorneys that are in this space advising those clients that are well versed in kind of the trajectory that's been happening within AI even over the last 5 years. But I think what I saw as the big turning point for us and probably for other legal practitioners is that like the acceptance of something like a chat GPT was easy to use. So I think unlike other technology trends, it was much more accessible to them, and they started playing around with it very early. And I think, the pandemic sort of helped with that too, of making these types of technology solutions more accessible to them and more curious about trying to adopt them. That we have, in the past, trying to implement, any new technology across a large firm could be a challenging endeavor from an adoption perspective. This is, one of the few times where I'm having attorneys reach out to me and my team with ideas of, hey, like, do you think this type of, generative AI can help us solve this problem? And we're trying to understand, again, like how that impacts the overall kind of workflow of legal service.
Well, can you help us understand that process? I guess from a certain point of view, you all are at an advantage because you have so many legal experts at your disposal there. But like, what is that back and forth? I imagine it's a healthy tension between you and your team on the technology side and some of the people in-house who are eager to use this technology.
Yeah, that's actually, again, been a very interesting trend. Like for someone like me who's been in technology for over a decade, I've always been, trying to find ways to, increase adoption and get new technology in the hands of users as quickly as possible. And there's, inherently always been that friction on, at least in my experience in the legal industry, of attorneys kind of changing, their workflow to adopt those new pieces of technology. With generative AI, I feel like those roles have switched a little bit, where myself and my team are a little bit actually more skeptical of just putting these tools in the hands of users because the space is moving so fast that it's much harder, I think, to control how these tools are being implemented within the firm. And there's a ton of enthusiasm on the attorney side of using these tools because they see the advantages of being able to be more creative with how they're delivering legal services to their clients. They see the advantages of being able to automate processes that maybe once were very labor intensive, that they can now spend more time on those high level thought leadership activities of how they advise their clients and less on the kind of day-to-day business operations work that they may have been spending a lot of time doing. So it's a healthy tension. It's just been a reverse tension, I think, of some other technology solutions or initiatives that have come over the last couple of years. But we're trying to do our best on the kind of professional and technology side to not lose that enthusiasm. So it's a healthy balance of, I think, education and making sure that our attorneys understand, what is generative AI? What are the tools out there? How do the tools interact with the way in which they are doing their work? And understand also the potential challenges of being able to apply this work in their day-to-day with how they're delivering services to their clients. Because I think a lot of times too, when you're seeing this with some of the, the tools that are implementing generative AI, it's not always clear that someone, when they're using a cloud-based tool that they may be used for the last 5 years, that there's a new generative AI feature that has been added to that tool that may go against a policy that one of our clients has implemented, and being able to provide them with the wherewithal to understand when they're using those tools is important.
When you think about technology and computers in particular, I think a lot of folks in their mind think of something like a spreadsheet, where it's predictable, it's repeatable, 1 and 1 always equals 2. But generative AI is a lot fuzzier than that. You can ask for the same question twice and maybe get different answers, and they're not always accurate. How do you contend with that within the law firm?
So that it's a big challenge, especially as we start to think about the automation of certain types of work. So I think early on, when the generative AI phase was kind of just starting, a lot of people thought that the transformation of this industry was going to be the replacement of lawyers. And I think that idea, at least right now, is something that is, I think, a myth that's never going to really come to fruition, because the tools can't do what a lawyer can do, which is be able to interpret a law and be able to come up with a creative solution to how that law applies to a particular issue that they are facing or using with a client. So I think we've tried to position generative AI as a tool that sits alongside legal practice that helps them to be more creative in how they are servicing our clients. So it's a problem-solving tool, it's a strategy tool, it's a communication tool that sits alongside, that allows them as the attorney to find different ways of tackling a particular problem and unlocking that creativity in a faster-paced way. So in a more traditional setting, they may have had to do more extensive legal research and spend a lot of time on the legal research side, identifying cases and combing through those. What generative AI has done with AI-assisted research has been able to do a lot of that just researching work early on and be able to provide the attorney with instant results of different types of cases, and then they can apply that to the particular problem that they're working on.
What about compliance? You mentioned compliance earlier, and it strikes me that has the potential to be quite a minefield in your situation.
It definitely is, and I think it's been one of the reasons why we've taken our approach to the adoption, especially of generative AI, has been maybe a little bit slower than some of our peer firms, but there has been a purpose to that, in that we've really focused on creating a foundational model of AI governance. So it goes beyond just having an AI usage policy for our firm, which we do, But what we've really spent a lot of time on is making sure we have systems in place to handle the various aspects of compliance, whether that be jurisdictional compliance or client-specific compliance, that we can make sure that we follow those processes in a way that allows our attorneys to understand when and where they can use these tools. We've seen one of the prime examples of this has been, most of our client engagements are bound by outside counsel guidelines, and a lot of times, even the definition of what AI is changes from client to client. So being able to have a standard terminology that is kind of what is Morgan Lewis's position on what artificial intelligence means, what generative AI means, was really important. So we created a standard list of terms for our firm of how we're approaching this. We can then use that to benchmark against what a client is deciding as their definition of AI, their definition of generative AI, and then how we apply those to the different tools that lawyers have access to, so that if there is an opportunity where a client wants us to use AI or generative AI in the delivery of legal service, we understand exactly what those requirements are, what their guidelines are, and making sure that our attorneys know exactly what they can or cannot do. Because in some situations, a client may okay a use case for generative AI. So they might allow AI-assisted research, or they may allow for us to use generative AI to create timelines within a litigation setting. In some cases, they may allow or disallow the use of specific tools or specific LLMs. So we've created a back-end database structure that allows us to keep track of all of those different requirements, so that as those things are updated, as tools provide access to new large language models or allow for new use cases to be deployed within the delivery of legal service, we have a way of making sure that that still complies with our client guidelines.
As you look at how things have gone so far, the efforts that you and your team are putting into this, the guidelines you're putting in place, the workflows and all those things, is your sense that this is long-term going to be a net positive?
100%, I think it's going to be a net positive. I think the timeline is going to take longer than people expect. As we look at just even the initial implementation of these solutions, there's a lot that needs to go into, I think, training and educating the end user on how, I think to your earlier point, how to get results as close as possible with consistency. And that's going to take time. It's going to take benchmarking and research around different types of models and use cases to get to that point. And I think within any industry, adoption is always the challenge. So again, we've tried to take this approach of generative AI is not going to replace necessarily people. It's going to be an augmentation to the work that's already being done. And there are areas in which we see that if we have a particular practice that is doing like high volume work, what generative AI, as an example, could do is provide that practice with the opportunity to scale that work without having to adjust necessarily the resources that are involved in that. So thinking about long-term planning of where a particular practice is going, and if we see opportunities to increase the output from that practice, implementing different types of assistance to ensure that that practice has the resources to scale as client needs kind of arise. But again, it's going to take a tremendous amount of time to make sure that there isn't, I don't believe there's going to be one kind of enterprise solution that everyone has access to that's going to change the way they work. There might be enterprise solutions that can generally help with day-to-day kind of business operations. But when you start thinking about in the legal industry, having practice-specific solutions for, our transactional practices that are doing M&A, that's going to be a different solution than for our litigation practices that need different types of tools to get the types of, the type of answers and solutions that they need that are going to, that generative AI is going to help them harmonize that practice in a much more efficient way.
Ben, what do you think?
Yeah, so sort of two thoughts here. One is it's interesting when we talk about lawyers because we don't really understand whether it would be beneficial for an individual lawyer to use AI tools given that lawyers work with billable hours. And generally you want to bill
Right.
more hours so you can make more money.
Right.
So if you're making your work more efficient, that might lower your bottom line. So I think that's something that's interesting as it relates to lawyers. The other thing here is that we have a real desert of expertise in artificial intelligence. This field is starting to grow, which is excellent. And I think we'll be in a much better place in 10 or 15 years, especially once we have specialty master's programs, for example, in artificial intelligence. My fear for the legal system is we're going to have a lot of cases and disputes that center around technical questions on artificial intelligence, or having a forensic expert come in and say, this is synthetic media or this is not synthetic media. And right now, it's impossible to find a sufficient number of these experts for all of the court cases that we're going to see. And it's particularly harder for defendants who are criminal or civil defendants or criminal defendants who don't have the type of means available to hire these forensic experts. So that's another thing that I certainly worry about in the longer term.
Yeah. No, it's really interesting just to hear Josh Rosenzweig's take on being kind of the work that he does assisting the lawyers and helping keep them on track. I guess what I'm getting at is the necessity for a large law firm to have someone with his expertise is not something I think we think about every day, but this is where we are. And, they're good on them for having him there.
Yeah,
and,
the job's the future.
Yeah, that's right. That's right. No, I really enjoyed the conversation. And once again, we appreciate him taking the time for us. Around every entry point and every clever attacker, Vectra sees the attacks others can't. How? Vectra has AI on it. Vectra's AI attack signal intelligence tells security teams where to focus, what matters. It wades through thousands of individual threat events so you don't have to. Attackers infiltrating your network? Vectra has AI on it. Attackers compromising your identities? Vectra has AI on it. Vectra AI, the integrated signal powering your XDR. Visit vectra.ai/showme to learn more. That's vectra.ai/showme to learn more. That is our show. We'd like to thank all of you for listening. We'd love to know what you think of this podcast. Your feedback ensures we deliver the insights that keep you a step ahead in the rapidly changing world of cybersecurity. If you like our show, please share a rating and review in your favorite podcast app. Please also fill out the survey in the show notes or send an email to caveat@n2k.com. We're privileged that N2K Cyberwire is part of the daily routine of the most influential leaders and operators in the public and private sector, from the Fortune 500 to many of the world's preeminent intelligence and law enforcement agencies. N2K makes it easy for companies to optimize your biggest investment, your people. We make you smarter about your teams while making your teams smarter. Learn how at n2k.com. This episode is produced by Liz Stokes. Our executive producer is Jennifer Iben. The show is mixed by Trey Hester. Our executive editor is Brandon Karpf. Peter Kilpie is our publisher. I'm Dave Bittner.
And I'm Ben Yellen.
Thanks for listening.